Hello and welcome to the Lyles Parker Provider Hour webinar series. My name is Ish Leha. My actual name is Ismail. Everybody calls me Ish. I'm glad to see that so many of you have taken the time to join us this evening on what promises to be a very interesting topic. If this is the first time you're listening, Provider Hour is intended to be a resource for providers to get up to speed with regulatory issues that affect their practice at a time that is convenient to them. The last two webinars we did at 8 p.m. We're doing this one at 6 p.m. We're trying to find that sweet spot that works for the most people. However, if this time is inconvenient for you or for your colleagues, you can always listen to the playback of this conversation tomorrow. It should be available online. I'm joined by Andrew Dubbs, who will be manning the controls and introducing the speakers. Andrew, how are you today?
Doing well, thank you, Ish. So as Ish mentioned, today's speakers are Jennifer Papaniotou and Heidi Coker. Ms. Papaniotou's practice focuses on compliance, regulatory, and transactional matters for a wide variety of healthcare providers, including home health and hospice agencies. She has extensive experience in analyzing proposed and existing business arrangements for compliance with federal and state fraud and abuse laws, and drafting a wide variety of legal agreements. Ms. Papaniotou is knowledgeable in all aspects of state licensing for home health and hospice providers and in Medicare and Medicaid enrollment, including initial enrollment, changes of ownership, and appeals of revocation actions. Finally, she assists clients with compliance plans, forming new businesses, and addressing Medicare and Medicaid program coverage and reimbursement issues. Heidi Coker is a partner with the law firm of Lyles Parker. She has over 20 years of experience advising and defending healthcare clients on legal and regulatory matters affecting providers of all sizes. She's an expert in all aspects of compliance and privacy programs, including developing and deploying policies, procedures, and training. Her experience includes serving as a Chief Compliance Officer and Chief Privacy Officer, implementing the various requirements and aspects of corporate integrity agreements, and responding to and defending audits from Medicare, Medicaid, and private insurers through all the ALG levels. She received her JD from Georgetown University Law Center. She is licensed in Texas and Maryland and is admitted to the U.S. Court of Federal Claims. She is certified in healthcare compliance. I also want to remind everyone that during this presentation, they and Ish and I will be available to answer your questions. So feel free to submit them in the question box you'll see on your screen. And now, without further ado, I will hand this over to our speakers.
Hey, Jennifer and Heidi, how are you guys?
Good.
Oh,
how
we're
are
doing
you?
good.
And how is everybody on the call?
The weather's wonderful in DC. The floor is yours.
Great. So this is Jennifer Papaniotou. I am speaking to you from Houston, Texas. It has stopped raining for the time being, thank goodness. Heidi, how are things up in Dallas?
They've actually stopped raining up here now too, and actually the sunshine is slowly beginning to peek out. We had quite a bit of rain earlier today, and actually because I have a voice over internet phone, my phones were not doing too well really early this morning. We had a lot of thunder and lightning.
Well, thank goodness that's cleared up for now.
Yeah. So before we get started, Jennifer does have a disclaimer for everybody, and I have one too. So Jennifer, you want to go ahead and kind of give a little bit of a disclaimer?
Sure. So first and foremost, Heidi, myself, and the firm of Lyles Parker did not represent any of the parties involved in the Forest Park case. I wanted to make that clear. And Heidi, you wanted to add another element to that.
Yeah, and just that, you know, we are talking about a lot of legal things here today, and, you know, Jennifer and I are attorneys. This is a law firm. We may answer some questions, but just be aware that unless you are already attorney or clients of the firm, we're not your attorneys, and you really need to go and check with your own attorneys if you have some very specific legal questions about your situation.
Right, and the last thing I would add, go ahead. Sorry, Ish, go ahead.
Heidi and Jennifer, just want to add, most of what we'll be talking about tonight is in the public domain. We don't have access to anything confidential things of that sort.
Absolutely. That was going to be my
Correct.
next statement. Everything we talk about tonight is available publicly, either through the court record or in published press releases from the U.S. Department of Justice or the Northern District of Texas. So with that being said, I thought it might be a good place to start is to sort of lay out for everybody who's listening who the cast of characters are in this saga. And
Jennifer, before you do that, what is this thing about? Just so people get an idea of the big picture. What is Forest Park all about?
Sure. So Forest Park Medical Center started as a physician-owned hospital up in the Dallas area. And their initial business model was to function as an out-of-network hospital that didn't contract with insurance payers. And to a large extent, their at least long-term plan was that they were going to be largely a private hospital. Private insurance was going to be their bread and butter, but it would be out-of-network billing to private insurance because there were some theories out there that out-of-network pricing could be aggressive, and that they were able to work the claims process to receive higher reimbursement if they function as an out-of-network facility than they would if they participated in network contracts. As a physician-owned hospital, they had some limitations on what they could and couldn't do with Medicare programs, or with Medicare program patients and other governmental pay patients. So many of the business relationships and other things that they entered into were complicated. They were, legal counsel certainly was involved in some of the conversations, many of the conversations, if not most of the conversations that I'm sure went on. There's no way somebody put together a project like this that's this big without legal help. So I will talk a little bit about the lawyer's role in all of this as we get into this. But that being said, so Forest Park is up, it's open, it's operating, and it is attracting physician investors from the community. And they're largely surgeons who are investing in the hospital who are going to do procedures at the hospital. Many of the folks that are actually mentioned in the indictment are either spinal surgeons, bariatric surgeons. There are some primary care physicians who are identified in the indictments, but obviously didn't directly send patients to the hospital necessarily. There are a couple of other kind of unique defendants that didn't fit that surgeon model. But in essence, what happened was they went out and attracted physician investors based on how lucrative they thought the referrals from that investor would be. And there's a long, long recitation of the allegations of how they created their investment model. But for purposes of the conversation today, there's some key names that are mentioned in the indictment that are worth reciting here. So there's Mr. Toussaint, Mr. Barker, Mr. Beauchamp, and Mr. Burt, who were really the primary four guys who founded the business. And then there were Beauchamp and Burt were really the people who ran it on a day-to-day basis. Once they had attracted their physician investors, or as part of attracting their physician investors, they came up with some unique and creative ways that they could not only incentivize these physicians to refer to this facility by making them part owners of it, but they could also find some other ways that they could presumably legally pay the physicians for some services that they may render to the facility. And there were a couple of companies formed that kind of questionable ownership arrangements, but I'll refer to them as the shell companies. And there's two of them that are important, Unique and Adelaide. And Adelaide, more than Unique, they were largely considered marketing companies that were set up and were funded by the hospital, essentially, that the hospital was going to give these companies money to do marketing for the hospital. Those marketing companies then turned around and entered into what allegedly were marketing contracts with many of the investor surgeons and with a number of surgeons in the community who were not investors. And these marketing, there were contracts that were drafted and Heidi, you and I have worked on contracts where various people provide marketing services over the years, and you and I both know marketing contracts just in and of themselves are kind of problematic.
If nothing else, they just raise eyebrows and questions just to start with.
Right. And there's been some OIG advisory opinions out there that talk about marketing services, and they don't. They clearly think they belong within the anti-kickback statute, that those can involve, because marketers can incentivize a stream of business to an organization when the marketer is an independent contractor, paying them on a commission basis or paying them on some basis that's tied to their success can be very problematic. But in this case, what was happening was basically Forest Park is funding these two shell marketing companies, and the shell marketing companies are allegedly turning around and handing the money over to the doctors, and there are these marketing contracts, and I put that in quotes, that they're executing with these doctors, but presumably the agreements look fine on their face, but they're not implemented the way they're written. And the doctors are effectively not doing much of anything in the form of marketing services and getting tens of thousands, if not hundreds of thousands, if not millions of dollars in money that's indirectly funneled to them through Forest Park, from the Forest Park entity, for these services. They're also receiving returns on their investments in the hospital. So there was another really unusual one that involved sort of the unnamed entity A, which was a commercial real estate company, and I guess that was leveraged in one of the deals with the doctors. The doctor was hired to be a consultant to their commercial real estate company or something. It was kind of a weird and interest. I've not seen one like that before. But there are a laundry list of doctors who were both investors and not investors in this entity. And what shocked me, and I mean, Heidi, you and I look at a lot of deals, and we certainly look at contracts for services and things that involve large sums of money. But I was staggered by the amount of money some of these contracts and investors were getting. So without naming any physician names here on the phone, there's a spinal surgeon that received something like $6 million in kickbacks. There's another spinal surgeon that received $5 million. There's a bariatric surgeon who received $3.5 million. Another spinal surgeon that got upwards of $1 million. Another bariatric surgeon that got $4.5 million. I mean, these are insanely large amounts of money.
and the point on these reimbursements and these payments too is this is not over the space of 10 years. This is over the space of a couple of years, maybe 3 years. So you can see there's a lot of money flowing back and forth on these payments in a very, very short time frame.
And these are not payments for services, meaning medical services. This isn't money these guys are billing and collecting to a payer. This is funds being paid to them indirectly through the hospital, from the hospital, from monies the hospital's billing and collecting. So this is in addition to whatever they made rendering their physician medical services as surgeons. So, I mean, really, really big dollars involved, which, I mean, I don't know what your thought is on it, but big dollars often incentivize prosecutors. They just, they see dollar signs and they make great press releases. And I think the round numbers I saw in this case were $40 million in bribes and kickbacks paid, with approximately $500 million in billing to federal healthcare programs and $200 million collected. And what's interesting is the federal programs were a small part of the overall services rendered at this hospital, if I'm not mistaken, right, Heidi?
Yeah, and actually I was going to give a little bit more color about how Forest Park got founded, if you don't mind, Jennifer, for the benefit of the audience.
Absolutely.
So if anybody is in the Dallas area, Forest Park is located just southeast, as you know, of Central Expressway and 635, and it is a beautiful facility. I mean, oh my gosh. The interiors, it looks more like a high-end hotel rather than a hospital, and that was sort of what one of the original goals was, to give patients sort of a spa-like kind of experience. And so they originally opened Forest Park with the idea to get Medicare patients as well. But I think within the first couple of months, very quickly realized that they couldn't get enough patients in with Medicare. And so they moved towards this out-of-network approach to billing. And of course, you know, anybody on the call knows that out-of-network gets you a whole lot more money. Part of the issue is that they didn't do a very good job of carving, and this is not, I'm not saying the out-of-network is right, but as part of this, they thought they were carving out Medicare and Medicaid, and they did. They carved out sort of traditional Medicare and Medicaid. But what they really didn't account for was some of these other programs that are federally funded programs. So for example, they apparently had a bunch of TRICARE patients. They had patients that were covered under federal workers' compensation programs. They had a whole bunch of patients that were employed by the federal government and had insurance that looked perhaps like, you know, standard private insurance. But again, because these were federal employees, their health care benefits were paid for with federal dollars. So
right, and as we health lawyers,
having
know,
yeah,
the anti-kickback statute applies to a federal payer regardless of who the federal payer is.
Right, right. So they
right.
had a whole bunch of patients, you know, coming with like Medicare Advantage plans and so on. So yes, they carved out their original, the you know, classic fee-for-service Medicare and Medicaid, but whoever was doing the patient sifting wasn't very savvy or very careful about sifting out all these other ones. So they actually ended up with quite a bit of federal dollars involved as well.
Right, and this kind of goes back, Heidi, to something that when we look at proposed investment deals, and I saw a lot of these over the last 3 or 4 years, carve-outs of Medicare, Medicaid, or federal or state benefit program patients are incredibly difficult to implement. They're difficult to implement and difficult to maintain if that's going to be the way you avoid application of various laws, whether that's the federal anti-kickback statute, federal Stark law, or a state statute like we have here in Texas. We've got a state illegal remuneration statute, and it's an all-payer statute. So there's really no way to carve yourself out of it, frankly. Some states have other types of what we would call mini kickback or mini Stark type statutes that maybe only apply to Medicaid or some other limited scope of payers. But many states have what we call all-payer kickback statutes, and Texas is a great example of it. So that being said, I interrupted, so please continue on.
No, that's fine. That's fine. The other thing that I wanted to give a little bit more color to was some of the marketing provisions. First of all, how they calculated the money. So when the founders, and in particular, Mr. Beauchamp, identified investors, when they reached out to them, they actually made a calculation, an estimation of how much money or how many surgeries and what the reimbursements for those surgeries would be, how much that physician could bring into Forest Park. So they were already kind of saying, okay, so-and-so will bring in so much money and so-and-so will bring in that much money. And so when they were approached, the Forest Park owners already had a pretty good idea. And the marketing payments went through, as Jennifer said, Unique Healthcare or Adelaide for marketing services, but they were pretty much based on, again, these estimates of how many cases people should be doing. And there was actually an individual at Forest Park whose job it was to monitor the cases and how many cases were being brought in by the various physicians. And if you didn't bring in enough physicians, then you were leaned on by Beauchamp. Either verbally he would pick up the phone and sort of tell you blah, blah, blah. But they actually had a bunch of emails that Beauchamp sent to physicians who weren't sending in enough business. So for one physician, for example, he said, "It appears your projections of cases have fallen whole/fully short. You said 20 in November and 40 in December. I want to sit down as soon after the beginning of the year and before the 15th to find out why my $150,000 investment hasn't produced jack." Close quote.
Right. Not exactly an email that you want to have flopped down in front of a jury.
Exactly.
Yeah.
So that was
yeah.
one thing. And the other thing is they actually did run some advertisements, but the way they did the advertisement was also problematic. So not only were they handing out money, but Forest Park actually placed advertisements in local media. The problem was these were advertisements about the physician. So let's say Beauchamp again was one of the founders. So Forest Park would put an ad out in D Magazine or Best Physicians in North Texas, and it would talk a lot about Dr. Beauchamp and how great he was and so on. And not a word was breathed about Forest Park. It was totally about the physician. So, they were spending these marketing dollars solely on the physician. And that was, one of the other ways that they spent marketing dollars on physicians. And the physicians had a lot to say about, you put this on and you use that photo and so on, but the payments were completely made by Forest Park. So
right.
That was another sort of part of the problematic issues there.
Sure. So we can turn a little bit to the legal side of stuff. And what did the government actually accuse? What were the laws that they alleged they broke? So there's sort of a laundry list, but they kind of all fall under generally the same theories. So the first count, and most of the defendants were charged with this, was conspiracy to pay or receive healthcare bribes or kickbacks. And under that, they included traditional kickbacks under the anti-kickback statute, and they were able to pull that in because of the federal payer programs that were involved. They alleged inducement to patients to choose the hospital, which is also under the civil money penalty provisions, but basically under the same area of the Social Security Act that the anti-kickback statute exists. Then they alleged violations of the Travel Act. And the way the Travel Act works, and Heidi, please chime in if you understand this better than I do, but essentially the Travel Act is a federal statute that allowed the prosecutors to rely on a state law, and in this case it was the Texas Commercial Bribery Statute, for a sort of an argument that there was the Travel Act really pulls in sort of interstate commerce type arguments that you're committing commercial bribery and involving interstate it's kind of was a completely new theory, I think, when these prosecutors went after the Travel Act violation. Right. Basically, we're going to take this federal statute and try to pull up a commercial, a state statute and apply it in a federal prosecution.
Yeah, and this has never, at least the Texas Commercial Bribery Act, to my knowledge, has never been used before in this way. It's really more intended for your straightforward commercial bribery.
Right.
What we all think of bribery. The waste contractors and the street repairs and so on. I don't think it has ever been before applied to federal. So that was new on a state level as well.
Right. Well, so I think it's interesting. I mean, I'll flash forward to how this thing ended up, and that is that they did get some convictions based on the Travel Act and the Texas Commercial Bribery Statute. So I was going to entertain everybody with a close reading of that Commercial Bribery Statute, if you dare to listen. But basically what it says is a person who is a fiduciary, and that term's defined in the statute, and it includes physicians, and it includes officers, directors, partners, managers, or other participants in the direction of the affairs of a corporation or association. So it pulls in my mind, the way they applied this, it pulls in that healthcare provider patient relationship. And it says, so a person who is in this fiduciary relationship commits an offense if, without the consent of his beneficiary, in this case that would be the patient, he intentionally or knowingly solicits, accepts, or agrees to accept any benefit from another person on agreement or understanding that the benefit will influence the conduct of the fiduciary in relation to the affairs of his beneficiary. So basically, boil it down to a physician commits an offense if, without the consent of his patient, he takes money to influence where he sends that patient. That's essentially what it means.
Unless it's disclosed to the patient.
Unless it's disclosed to the patient. And you and I were having a very interesting conversation about that, because there's, under the Texas Illegal Remuneration Statute, there's a provision that basically says, it's a mini anti-kickback statute. It looks very much like the federal anti-kickback statute. And it says, okay, here's the Texas law. It applies regardless of who the payer is. We're adopting all the federal safe harbors, which, are essentially legal conduct under the anti-kickback statute. And then it says, even if you comply, you have to tell your patients about your financial relationships with places that you refer them. And it's
right.
Interesting because that concept lives under this commercial bribery statute as well. So I know you've had some interesting conversations about that aspect. What do patients know when they show up?
Yeah, so and that actually gets into sort of the other aspect of this. So again, these were all out-of-network patients, and they were, when they would get a bill, it would be at the out-of-network rate. So everybody was kind of freaked out by that. These physicians knew that the out-of-network rates would be high, but because you're out-of-network, that also means your patient copay is going to be high. So there's a couple of interesting aspects with that. So one of the things is, as Jennifer said, if you have this fiduciary relationship, the question arises is, number one, are you going to disclose to your patient that you're out of network? And then number two, because you're out of network, that means the patient is going to possibly have higher amounts to pay on their copay or their deductible. In other words, they have more financially at risk by going to an out-of-network hospital,
right? And
such as Forest Park. And so they actually, again, tried to get around that by waiving part of the patient's copay to bring the patient responsibility down to what it would have been had Forest Park been in network. So you've got the double whammy there again. You're failing to disclose what the correct amount is, which puts you in violation of this Texas state law. And then you're waiving the patient copay, which puts you in violation of your insurance contracts. And, if you've got the federal programs, you're in violation of the anti-kickback statute there again. So, I think it's just really interesting a question as to if you have any kind of a relationship, be it an ownership or a compensation relationship, how much disclosure do you have to do for your patients? And if you have a patient coming into, let's say, the hospital, you can't do that disclosure when they're sitting in the lobby signing their admissions paperwork. That's way too late to be an effective disclosure. You have to disclose that further on up in the process, so that you, again, the beneficiary, and I use the beneficiary not in the sense of the Medicare beneficiary, but the beneficiary of this fiduciary relationship, that the physician is the fiduciary, the beneficiary, the patient, has options and understands what's going to happen.
Right.
So I think one of the open questions out there is how do you disclose any such relationships? How much disclosure do you have to do? Do you have to put dollar amounts on that? Or is just, we've had this discussion, Jennifer, is it enough just simply to say, I have a relationship with XYZ laboratory or ABC hospital? Do you have to say, I have a relationship with this other entity, and because we may be going out of network, you might have greater expenses? how detailed do you have to make a disclosure? I think is still very much an open question. But I think based on what we saw with Forest Park, the answers are going to be you have to disclose more than people have been to date.
Right, right. I agree. I think there's a bit of a big gray area right now. Now, we've always written disclosures for our clients in states where that's required. And Texas is an example. Even if you comply with a safe harbor, even if your relationship is completely, within the law, you still have to disclose to your patient that you have a financial relationship or an investment interest in some entity that you're either a direct or an indirect owner of.
Right.
Or you just indirectly have some kind of compensation relationship with. And I see this come up a lot in when physicians invest in management services organizations that then are contracted with ancillary services like lab, pharmacy, et cetera. And they're like, well, what do I have to tell my patients? And my response back to them is you have to, in the past, the way we've looked at this is when and how do you do it and what is the language? And it shouldn't be something that's buried in 3 pages of tiny print, right?
Right.
I don't know that any
14.
regulator is going to really accept that that's effective consent if you are, if you're looking at what the terms of the commercial bribery statute require. I think it needs to be more obvious than that. Again, time will tell. I can say that I think it's really important that we have that conversation with our clients who are investing in things other than just their primary practice or their, primary provider entity, so that they know they have these responsibilities. And then we can talk through on any specific example what makes the most sense. For these Forest Park doctors, these guys that invested in this hospital, what would have been enough? Well, it seems to me they should have had disclosures in all of their intake documentation for their patients in their primary office. And if they ever referred a patient or suggested the patient go have surgery at Forest Park, it should have been, fairly obvious to the patient that, hey, doctor's disclosing, I have an ownership interest in that hospital. I have a compensation relationship with that hospital, or, whatever applied.
And waiving the amounts does not get you out of that disclosure
Absolutely
requirement.
not.
I think is very important, because I think a lot of times people say, well, I just won't charge the patient, and if I don't charge the patient, I'm okay. No, you have a disclosure relationship independent of whether or not you actually charge the patient.
Right. So the waiver of copay and deductible, the facts that are shared in the indictment and the various court documents are a pretty standard out-of-network waiver of copay situation. Patients would come into the hospital for, I'm sure, preoperative work or admission work, and they would tell them, okay, we're out of network, and we're gonna bill your insurance company for you, and you're gonna get an EOB, and it may look a little weird, and the amount, the patient responsibility amount may look really out of whack, may look weird. You just call us when you get that and let us know, and we'll take care of it.
I've heard that language so many times in similar circumstances, and every time I hear that kind of stuff, it just makes me cringe, because I know we're going to have a problem.
Well, and it's not just the Forest Park case. Forest Park is the most recent case. It's not the first case.
Right. Right. Yeah.
There have been some pretty well-known civil cases that alleged commercial fraud, essentially, where out-of-network hospitals were waiving copays and deductibles, and the insurance companies basically said, hey, hospital, when you send me a claim for $1,000 and I pay you $500 and you don't collect the $100 deductible from the patient, you've lied about what you really charge for the service, and that's fraud. And they've won those cases. And so this concept,
and not just some cases, they win those cases all the time.
Routinely, right?
Routinely, yep.
So what's disturbing here is they've taken something that was happening more often, at least in the recent past, in the commercial litigation space, with insurance companies suing out-of-network providers. And I mean, you know, they've elevated that to a new level with a federal prosecution of, you know, how many people were involved, ultimately 21 defendants in this case. And I did a quick count. There were 10 pleas of guilty. 7 were convicted after a jury trial, 1 mistrial, and 1 person out of the 21 was dropped. And I mean, kudos to his lawyer, however he got him out of it. So it's, and I may have my numbers off just, I think that's 20, and I'm missing 1 person who I couldn't figure out what happened with one of these defendants because it just wasn't clear from the federal court record. But we often say people who are accused of healthcare crimes and are prosecuted for healthcare fraud crimes specifically, the government's conviction rate is extraordinarily high. They are really successful in getting people who are accused of these healthcare fraud crimes to either plea or they win at trial. And I mean, it's the rare defendant that wins one of these cases, which is it's unusual in the big scheme of federal prosecutions. I don't know what you think about that, Heidi, but I know that one of the reasons when we advise our clients, we repeatedly explain to them the anti-kickback statute is a federal criminal statute. It is not, you're going to just pay money back. They're putting people in jail over this stuff. And it's one of the reasons why we're
going to jail.
Right. And when we advise people about complying with these statutes, it's one of the reasons that you have to be cognizant of how the law is being interpreted by the regulator who writes the statutes and doesn't write the statutes, but writes the regulations that implement the statute, that interpret and apply the statute on, a day-to-day basis. How the courts are interpreting those statutes and applying them. Do they agree with the regulators? Do they not agree with the regulators? But it seems to me that the criminal prosecutions have been overwhelmingly successful, and that may be because the prosecutors are good at picking winner cases. They don't want to take a case that's hard to win. But it's one of the reasons why when I advise clients on things that may involve the anti-kickback statute, you need to be extraordinarily transparent with your lawyer about what the deal is, right? I suspect
and you bring
and I want you to talk about the defense of counsel defense that was thrown up here. But why don't you go ahead and do that, and we can dig in there.
Yeah, let's segue into that. So one of the things that actually has been a defense all along, even before it went to trial, was many of the defendants. As Jennifer said early on, this kind of transaction cannot be put together without the help of lawyers. So there were lawyers involved at every stage of the process in terms of creation of the Forest Park entity, creation of Unique Healthcare Services and Adelaide Business Services, and all these subsidiary entities, the real estate group. There were lawyers involved in every step of the process. So they were also the ones that created these marketing agreements. So one of the defenses was, hey, my attorney reviewed this agreement. My attorney is a licensed attorney. My attorney would never steer me wrong. And in fact, my attorney actually basically blessed these agreements. And so to that end, some of the defendants actually put their attorney as a witness on the stand to talk about, how they had arrived at these kinds of things. And one of the things that I have actually seen in my past is attorneys who are not familiar with healthcare law, and they create a transaction. They do, sale or purchase or management documents or some other contract, an employment contract, and they're not aware of everything that goes on with healthcare, and so they inadvertently cause issues. Sure, you can pay a referral payment, or you can pay them, percentage compensation based on productivity. But this is not that circumstance here. These attorneys actually were healthcare attorneys and knew what was going on, and did create and draft agreements that at least 6 years ago I would have said fit within the terms of the various anti-kickback statute, the safe harbors and exceptions under the Stark law and under the Texas law. So they actually put this attorney on the stand, and actually the government's approach to this was, you know what, we're not even going to argue about the legality of the agreements. We will agree that the agreements on their face were legal. The government's argument was the clients, however, these physicians, did not tell the attorneys everything that was going on. So yes, they told the attorneys only enough or such facts so that the attorneys would essentially give a favorable opinion and draft marketing agreements that, you know, passed muster.
Right. So the flip side, go ahead, Heidi, finish what
I was going to say,
there.
And so actually, one of them actually put his, again, attorney on the stand, and the attorney said, well, I spent a lot of time with these guys. I knew what they were thinking. It's not just that the agreements themselves were legal. I think I knew what was going on in their minds and what intent they had. And again, under the anti-kickback statute, anybody who's had, you know, anti-kickback training knows that we always harp on intent. So this attorney said, I do think they had legal, correct, proper, that's the word I want, proper intent. They didn't have the intent to improperly reduce referrals. And obviously, that didn't work because the testimony and the evidence came out that maybe that's what they told the attorney, but then they turned around and, like I said, I quoted you that email that Beauchamp sent to a physician saying, hey, you guys, you didn't send me enough, you know, cases this month. So I think that brings up a couple of things. So, you know, obviously, yes, you want to have attorneys look at this, but I think a real key issue here was you can't just tell your attorneys enough to get away with it. You have to be really open. And I always tell my clients, and Jennifer, I'm sure you do this too, but I always tell my clients, you know, I have to know everything. Tell me the good, the bad, and the ugly, because the only way that I can help you is by knowing even the ugly facts, the bad news that you have out there. That's the only way that attorneys can really protect you, is by knowing everything. And so this attorney gets up on the stand and says, I think I know what's going on in their minds. And then the government reads an email to them that says, well, you know, your client sent this email, and what can the attorney do more than sort of shrug and say, I didn't send the email.
Right.
So I think it's really problematic.
Right. Well, the flip side, and I agree with everything you just said. You know, we endeavor every day when we talk to clients to ask the right questions, and oftentimes clients don't know what information you need, and so it's important to try to clarify with them. You know, here's what the law requires. Here's what I think I need to know. You tell me anything else you think might be important. You know, these can be complicated conversations, because it isn't always apparent what's the important fact that's missing from the equation. So setting that aside, you know, transparency is incredibly important. And so when your lawyer gets on the phone with you and wants to ask you a million questions, and they seem weird and irrelevant to you, they really are. they're issue spotting, right?
Well,
the flip side of that is, go ahead.
I was just, and you may be going this way as well. You know, I also have clients that will ask any question, they will answer any question I put to them, but they only answer the questions that I put to them. They never tell me anything other than answering the specific question that I put to them.
Right.
And even if it's a legit proposition and a legit transaction, you know, they don't tell me everything that I need to know to make sure that everything, all the boxes are checked, everything is tied, and it really,
Right.
I think, and Jennifer, I'm sure you agree, I think it really diminishes my ability as a lawyer to help protect my client.
Right. Agreed. So the flip side of this is A, be transparent on the front end, and then B, when you pay your lawyer to write a document and to advise you on the right way to do something, you have to implement it that way. You have to do what they said you can do. And I think that was another part of the problem here, is you had these agreements that were facially valid. The government wasn't going to argue over whether the document as it was written was valid, but they did not implement them the way they were written. And this comes into, I wrote a contract, or they wrote a contract for a marketing service that the physician was supposed to provide, but they had no way to show the physician actually ever did anything. So it's an illusory contract because there are no actual services being provided. We find this, and it's one of the reasons why when we write things like medical director agreements and other independent contract agreements, we harp on clients about what documentation are you going to keep that the services outlined in this contract and the money you paid was for real services. It's an incredibly important part of the compliance side of any of these arrangements.
I would agree completely that you have to have, the documentation of the services, because otherwise you end up, with it being an open question.
Yeah.
And the other thing that struck me as really interesting about Forest Park too was, again, when you have a government investigation like this, they come in, they will take your hard drives, they will take copies of documentation, paper documentation, and once they get hard drives and get into your email system, they have all kinds of emails. And I think this is how clients really shoot themselves in the foot. Again, they tell their attorneys, oh yes, we're going to do, ABC, we're going to be compliant, we're going to do ABC. And then they turn around and they send an email saying, hey, what's up with Nick doing cases for his $70,000? As I recall, we had to do 15 insurance bypasses a month for that $70,000. It shouldn't be any lower since he's also getting paid by the partnership.
Right.
I mean, it makes my hair fall out when I get emails like that. And I'm not suggesting that if you're going to do something bad, don't put it in an email. I'm suggesting you shouldn't do anything bad in the first place,
Right.
let alone email.
I had a conversation. I often
huge email trail.
Yeah. Email is. I think you and I would agree that email is the single biggest source of smoking guns these days. It's no longer the internal memo. Because companies just don't write things. They don't operate the way they did 25 years ago, right?
Right.
Communications among members within an organization and going outside of the organization are incredibly problematic. And what people put in an email, it lives forever, frankly. It's really difficult.
Well,
and the government, what's really disturbing about it, here's another interesting element of it. Most email, a lot of times, is hosted someplace else. It's hosted by Amazon Web Services or Microsoft or Google or something like that. They can go grab your email and you won't even know it. Because they subpoena it directly.
Yep.
They subpoena it directly from whoever's hosting it. And
guess what? Now you have interstate commerce again too.
Right.
Because your emails are hosted someplace else. So boom, there you go. Now you have interstate commerce, which brings into the federal statutes, the anti-kickback statute, or like here with the Travel Act. The Travel Act was the interstate commerce piece. On that. So. Right.
So I wanted to touch on a couple of the other. I mean, there was money, right? There was straight up money being paid, and then there were some other things that were pointed out in the course of the case that they highlighted as behavior they saw that was potentially problematic, either under the anti-kickback statute or the commercial bribery statute. And there's sort of a hit list of, as healthcare lawyers, we've been preaching to clients for years and years and years, these are things you shouldn't be doing, right? Waivers of copays and deductible are a big one that has been on everybody's radar for a really long time. Obviously, paying doctors directly or indirectly for referrals has always been a big no-no. But they had we're going to rent space in the doctor's office and then it's not really used for anything. It's just we're going to pay some rent for a closet or a shelf or something, right? So to slide a little money that doctor's way or that chiro's way or whatever. They had the paying patients travel and lodging expenses to come have procedures at the hospital, which is another form of inducement to a patient. They were giving freebies away to their physician referral sources, tickets to concerts, sporting events. I read a laundry, custom boots, free car washes, fine dining, and my favorite, low cost or below market office space. I'm still shocked at this stage of the game, when the anti-kickback statute has been in place as long as it has, that we are still seeing examples of below market office space being offered by hospitals or their affiliated entities to physician referral sources. Just shocking.
Some of the other ones too that I liked were the I shouldn't say liked, but I know there were the sham consulting agreements. So they entered into an on-call agreement for the emergency room for the one physician, in which he was being paid $30,000 a month for a consultant and for on-call services. Wow, $30,000 a month, and he really didn't do much of anything. And then here's the funny thing. This actually made me laugh. So the physician that actually got that sham agreement then used it to secure a loan so that he then got cash from that he then used to invest in Forest Park, so that he could get, partnership profits then, which I think, if the bank had really understood what this was involved about, I think the bank would have come absolutely unglued. And, the bank, I don't know if they ever got their money back from, the bank gave him a $500,000 loan, a $500,000 loan to invest in Forest Park. And, Forest Park eventually went bankrupt. So I'm sure the physician didn't get his money back. And I don't know if he's declared bankruptcy or not, but I'm pretty sure the bank is not getting its money back. And I'm sure the bankers are a little unhappy about that.
Everybody loses in these situations. I know they're probably, I'm sure there are a million stories and there are a million different versions of the same fact pattern. I'm sure many of these physicians never in a million years thought this was going to go the way it did. But when I talk to clients about these kinds of investment deals, and I've seen some crazy investment deals over the years, but the reality is this, and I know this is simplistic, but frankly, simple is sometimes better. If it looks like the deal is too good to be true, and it's a healthcare deal, it probably is problematic. I know no one wants to hear that, but the reality is, if you're a practicing physician and somebody walks in and says, "I have a deal for you. I'm gonna give you a completely new line of revenue, and all you have to do is give me $3,000 or $5,000, and you're going to invest in this management company, or you're going to invest in this provider entity, and you're going to see a 50-fold return on your investment," there's something wrong with that. That is not the way the healthcare industry has been designed to function. And there are certainly federal and state laws out there that are specifically geared towards preventing that kind of investment relationship or compensation relationship.
I think
like
my
duck
big
at the duck. I mean, That's
yeah.
I
think one of my big takeaways is if your attorney tells you it's illegal, and don't try to, be cute and work around behind your attorney and figure out that if your attorney doesn't know about it, it's okay.
Right.
There's a reason that we provide the advice we provide, and it's really, I think, frustrating, and I'm sure their attorney was pretty frustrated too, where he created these agreements and said, here are the guidelines you need to live within, and then they went and didn't live within those guidelines. And as an attorney, frankly, the last thing I want to do is be hauled into court and be a witness for my clients explaining,
right.
Why I created an agreement a particular way and how it is that, my clients could have violated the law by using an agreement I drafted.
Right. Well, we've got about 5 minutes left, so if anybody has any questions they want to put up in the chat screen, Heidi and I are more than happy to answer them. I guess my takeaway while people are thinking about whether they want to ask anything is, I asked the question when Heidi and I were preparing for this, what's my takeaway from this? What have I learned from the Forest Park case? And there's a couple of things I know, and Heidi, I'll throw out one or two of my big ones. One of them is the carve-out is dead. There is no reason anybody should be relying on a carve-out of federal or state healthcare benefit program patients to make a deal legal. With the Travel Act prosecution, the successful use of the Travel Act and the commercial bribery statute in Texas, and the fact that a lot of states have all-payer anti-kickback statutes, there is no way anybody should even remotely be thinking that a carve-out deal is a good idea. Period.
I would agree.
I don't know what your thoughts on that, Heidi, but that was one of my takeaways from this. And the other one is that, as you've said just eloquently now, be transparent with your lawyer and follow their advice. And I know of scenarios where if I'd only known an extra fact here or there, or if that lawyer for Forest Park had only known an extra fact here or there, or if they had actually followed their lawyer's advice and implemented these relationships the way they were told to do it, maybe they wouldn't be where they are right now. But that's
instead we have, and that's, I think, one of the things that people don't realize what the downside is. So we have a number of physicians who have pleaded guilty. Some of them have actually started serving time already. We have others who chose not to plead guilty and went to trial. And trust me, they spent a lot of money on their defense attorneys, and they lost at trial. Now, I'm sure they're going to appeal, but I really don't have a whole lot of hopes for the appeal. But here's the other thing. If we have physicians on the call, you all have worked so long and so hard to get to where you are with your license. Why would you jeopardize it with something like this? Because these guys, I went back and I looked at the guilty pleas that were signed. In each and every case, the physician is going to be excluded. In each and every case, the physician is paying a forfeiture or a fine. So if they got some amount of money, a good portion of that is being disgorged to the government. So no, your Mercedes is not safe from forfeiture. They're spending years in jail. And although we haven't followed up on this, I'm sure that because of this, because they are guilty of felonies, the medical boards are going to strip them of their licenses. So when they get out in 5 years, they now have to come back in front of a medical board and tell the medical board how it is that they have been rehabilitated or why their license should be reinstated. And once you've done that, then you have to go back to the OIG and say, why should I be let back into federally funded healthcare programs? I'm excluded. And both of those are discretionary actions by both the medical board and the
OIG.
OIG.
Absolutely.
They don't have to let you back in. And, most insurance contracts that I've looked at lately have as a prerequisite that you not be excluded and that you be enrolled in Medicare and Medicaid. You know, if you can't get into Medicare and Medicaid, you're not practicing medicine anymore. Why would you do that? Why would you put all of that at risk is one of the things that I think is really just puzzling to me.
I echo everything you just said, Heidi. And we have, I think we have maybe 30 seconds left. And I just want to thank everybody for tuning in. I appreciate your joining us at, let's see, I'm in Houston, so it's 6 o'clock now. And Ish, I'm sure
7 in
there'll
DC.
be
7 in DC.
I'm sure there'll be a notice going out about our next provider hour and the topic that we'll be covering then. But I appreciate everybody listening today.
Thank you, folks. Thank you, Jennifer and Heidi, for a wonderful, insightful presentation. Take care, guys.
Bye-bye.